Good morning, everyone. Thanks for coming along. My name's Wade Pearson, and today we're going to be talking about the legal side of starting your own business, or specifically your own game development business. So first, I'd just like to set the scene and find out a little bit more about you. I've met some of you already, but could I get a show of hands? Who here is running their own studio, their own business, making their own game? Okay, so a few. Who here's maybe thinking about it one day or planning to do it in the future? Okay, a few more. Yep, cool. I'm going to put my hand up. Maybe that'll happen one day. We'll see. And who here feels perfectly comfortable with the law and what they need to do legally? Well, we've got one. Good man. You can leave. It's sort of. Oh yeah, there you go. Good. You can pull me up if I get off topic. And who here finds law interesting and exciting and comforting? Any of those words jump to mind? No? Oh, we got okay, cool. We've got a couple. This is great. Yeah, generally not what kind of comes to mind, right? So we've got kind of three real purposes today. So one is we're going to learn a few things. There's a whole lot of knowledge and education in here. Two, I'd like to really empower you and reassure you that law doesn't have to be scary, it doesn't have to be intimidating or complex. There's a lot you can do yourself and a lot of basics that you can get right, and you get those fundamentals and everything else falls into place. And the third thing we'd like to do today is to have some fun and hopefully enjoy the next 50 minutes. So let's get underway. First, I'd like to talk a little bit about me. So this is my son Elliot. He's just turned 2 and I love him to bits. He normally does smile more, but it was really difficult to get all of us smiling and looking at the camera. So that's Elliot. On the other side is my wife Radi. I also love her to bits. I forgot to say that in one of the run-throughs and she was very unhappy, so you all heard me say it. We're both from Dunedin, and Dunedin's our home, but we did live in Wellington for 4 years, and we actually got engaged about 500 metres that way over at the Amora. So it's been great to be back in Wellington, and I've had a blast over the last couple of days, and really looking forward to the rest of the conference too. This is me. I'm a PC gamer and board gamer mostly, although I've been inspired to get back into mobile gaming with some of the talks I've seen over the last couple of days. I'm a commercial lawyer, so what I do is I help businesses do good things. I work for Galloway Coquelin, which is a law firm in Dunedin and Otago. We've got an office in Wanaka too. We do a whole bunch of things, but really the area I focus on is startups and technology and commercial and business and all those fun things that everyone loves, right? Everyone's on the same page? Cool. I'm also chair of Startup Dunedin. Who here has heard of Startup Dunedin? Good, yeah, I just told you about it a minute ago. So, okay, so 3. So not a lot, that's probably right. Who here's from Dunedin? Yeah, okay, about the same. So Startup Dunedin is a non-for-profit trust that looks to grow and support the startup ecosystem in Dunedin. So if you're ever looking to start a business, you want some advice, you want some help, they're the place to go. And we do a lot of work with them to kind of help various startups. We've also got Code in Dunedin, which is awesome. There's a whole lot of new studios coming through, and so really part of this talk is to help give you a bit of confidence that you actually can do this stuff and you can give it a go. So we've got 5 points we're going to cover today. We're going to go through pretty quickly. We do have time for some questions at the end, hopefully, and you can submit them through the app if that's easier. These are, for me, the top 5 points that come up again and again, and they're 5 points that you should think about and maybe take away a tip or two for each one. So we'll talk about making a company and having an entity to actually be the studio. We'll talk about that relationship with co-founders or anyone else who's working with you in the business. And that leads to people who work for you, so your contractors and employees, and knowing the really important difference between the two. We'll cover intellectual property, which is probably your key asset. It's a really important topic. And we'll also talk about contracts, which is a lot of fun. I really like contracts because I'm quite weird, but that's all right. So, first we're going to talk about company. Does everyone know roughly what a company is? Some nod. So it's an entity and it's a business structure. And when we talk about business structures, often you'll have a lawyer come up and say, oh, you can be a partnership or a limited partnership or a trust or a sole trader. I'm going to kind of simplify it a lot and leave out a lot and just say, look, make a company. It's really quick and easy and cheap. It costs about $150. You can do it in a couple of hours, although allow a couple of days. And it's so easy you can do it yourself. And if it's just you in your studio and you're going to be the sole director, the sole shareholder with all 1 million shares, great, do it yourself. That's actually pretty easy. You don't need to pay a lawyer or an accountant to do it for you. You can go on the website and it's all pretty straightforward. If you've got co-founders with you, that's when you might want to talk to a lawyer or an accountant or some form of advisor, because things can get a little more tricky. We had a client who didn't do much in their initial stages. I mean, they came to us, just their cap table, like all their shareholdings were a real mess, and it probably cost $20,000, $30,000 to kind of unpick that, and if they'd had that advice early, it might have been $5,000. So, and this is a theme of today, is that law isn't all about this big lawsuit that took you out of business and it's all doom and gloom. Sometimes it's just, you end up spending a bit more money, or your game doesn't sell as many copies as you'd like, or you have some problems with people, It's not all doom and gloom. In terms of when to make a company, I think the earlier the better. If you do it too early, okay, you spend a little bit of extra money and you've got some extra obligations, but it's not too bad. If you do it too late, that can be a real problem. You might end up with some personal liability, which we'll get to, which is not too much fun. Or you might just get into a kind of a sticky situation where, it can be messy. So I've talked about the how, but you might be wondering about the why. And there's 3 main reasons why you incorporate a company. One is just legitimacy. It looks more professional. It's easier for people to deal with you. It's a structure that most people understand in the business world. Growth is probably the main one. So if you just want it to be you and you're just going to make one little game and that's kind of it for the rest of your life, that's probably fine. You might just do that yourself. If you want to bring more people on board, if you want to grow, if you want to attract investment to be able to grow, really a company is your main option. And that just makes life a lot easier and a lot simpler. The third one here is liability. So we won't go into this too much because as a game developer, the risks aren't as huge as, say, being a lawyer or a doctor or something, or financial advisor where you get sued for millions of dollars. But the principle here is when you make a company, the company is the one that does all the things. So the company employs people, and if those people get angry and sue you because you fired them or whatever and demand a whole bunch of money from you, they're actually suing the company. So the company can take that hit, but it's not you, and it's not your house and your car. You're not ending up bankrupt, apart from certain circumstances. So it makes life a lot easier and a lot safer. There are some really important exceptions, but generally you're in a better position in terms of liability. So who here does have a company already? For those who are, okay, yeah, we've got a few. Great, that's what we like to hear. A few little tips just to make life a bit easier. Use it for all your accounts and all your things. I've seen people who have made a company and they go, great, and then they send you the invoice and there's nothing on the invoice to say that it's actually that company. So there's a risk that, I'm thinking of one guy I know, he may get into trouble where the person says, no, I didn't know you had a company, and I didn't like the work you did, so I'm going to go after you personally, and that's a real risk, right? For some developer accounts, you can end up in a sticky situation where you've used whoever happened to sign up for it, their kind of high school Hotmail account, like seymourbuts@hotmail.com, something like that, and that can be linked to your studio account forever, and that's really awkward if you get into that position. So make a generic one, hello@blablagames.com or .nz or whatever, and just be clear that you're doing things as the company rather than as you personally. Company name versus trading name. Who's heard of Flight Coffee? Yeah, we've got a couple. Okay, yep, good. I was there this morning, funnily enough. They make coffee and they've got cafes and very good coffee. So they trade as Flight Coffee, but their business name is Inigo Montoya Limited, which is great if you get the Princess Bride reference. And if you don't, like my old boss, I had to explain it to him, and yeah, I lost a little respect from that day. So you don't have to have the company name the same as your business name. And often it isn't, because you don't know immediately what you want to how you want to position yourself in the market, what your brand is, all of that sort of thing. So you can have different names, but whatever you do check the name. We'll talk about it a bit more at intellectual property, but you can get into trouble if you wanted to make a company called Balancing Monkey Games. There already is one, so don't do that. I mean, Sam would be pretty nice about it, I'm sure, but you don't want to be in that position.
Which way around is it?
So the company name is the legal entity that you create on the Companies Office website, and that can kind of be whatever you want as long as it doesn't breach someone else's name. Your trading name is what you'll call yourself. So Flight Coffee is the trading name. Inigo Montoya Limited is the company name. If you do have a company, just be aware of directors' duties. So there's the Companies Act 1993, which is quite long, and there are other common law obligations. Essentially, you've got some duties as a director. You need to act in good faith. You need to act in the best interests of your shareholders. You can't go out and incur some obligation to pay someone money if you don't think you'll be able to pay it. And if you breach those duties, that's when you get into trouble. And it's generally when the company's gone under anyway, because you haven't made enough money, basically. And that's when you can get into a lot of trouble. So it is worth actually reading a few articles, just understanding what those mean and how do they apply in practice. Because there is a little more compliance and a little more admin than just doing everything yourself as a sole trader, is the point there. So the tip here is a very simple one, is make a company. Go on the companiesoffice.govt.nz, have a poke around. There's a whole lot of guides and explanations around how to do it. If it's just you, nice and simple, great, do it yourself. If there's a few more people involved, then maybe have a think, maybe have some initial discussions and get that sorted beforehand. And that's it on company. That's the easy one. We're going to get a little more complicated now, but hopefully you'll stay with me. So co-founders, who here's played Fortnite, Apex Legends, anything, or Overwatch, or some kind of competitive multiplayer game? How does it go when you drop in and you just all run off in different directions and you haven't talked about your strategy, and it ends badly, right? Every game of Fortnite I've played, I've just died immediately. The only one I did really well at was Spellbreak. So my first game I went in and I won, and I felt so good until my friend said, the first game they just put you in with bots. So I'm not actually good at all, and I kind of crushed my heart a little bit, but that's all right. So your co-founders are like your squad, right? They're your teammates. So you might call them shareholders or partners. Don't call them partners. You might have investors on board. These are the kinds of people we're talking about, and this is one of the biggest areas where you can get into trouble. Co-founder disputes you'll see come up time and time again as something that does actually potentially destroy the studio or the business. So when we talk about co-founders, really the key thing here is to have what's called a shareholders agreement. Has anyone heard of a shareholders agreement before? Yep, some nods. Anyone got one? Yep, cool, great. Preaching to the choir. So a shareholders agreement, or there are other words, you sometimes hear a constitution. It's basically a document that sets out those rules of how you're going to work together. And it's really important. It's kind of like a prenup, or a Section 21 agreement, we call them in New Zealand. If you're going to marry someone, you might have an agreement around what happens if you break up and how that works. And what I like to say is, even if you don't end up with that agreement, having that discussion around money and kids and all those kind of bigger things, that's a really good thing to do before. I'm not giving relationship advice here, by the way. Definitely not. But it's really good to have those discussions beforehand. We had a client and they said, right, let's get a shareholders agreement, and there was two of them. One was putting in money, one was doing all the business work, and it just dragged on. And I kind of knew at the time, I was like, okay, this isn't great. And we'd kind of prompt them along, go, hey, have you thought about it a bit more yet? Have you made these decisions? They had a draft and everything. Never got signed. The business failed, and then it got really messy because they hadn't done that. And in hindsight, the fact that they couldn't agree on how we're going to work together is a really big red flag, right? And if you can't have those discussions, which are a bit uncomfortable, then that may well be a problem down the line. There's a lot that goes into a shareholders agreement, so I'm going to shoot through a lot of this. At an early stage, you want to try and talk with your co-founders around what your roles are, who's going to do what. This might change over time, but at least you can have that discussion and have some boundaries and clarity between the 2 or 3 or 4 of you. Vesting is a fun one. Anyone know what vesting is or have heard of it? Sweat equity is another term you use. It's talked about a bit. It's not always that well understood. People read articles from the US and they do it a certain way, and it doesn't really translate to New Zealand in the same way. So it can be very messy. Anytime someone says, oh, we've got these vesting arrangements, and I go, did you do it with the lawyer? And say, no, we did it all ourselves. We found an article online. And I go, okay, this is going to be fun. So vesting is basically the idea that normally when someone works or puts in some effort, you pay them some money, right? But often you don't have the money to pay them, so you give them shares. You give them part ownership of the business. And vesting can mean a whole lot of different things, but essentially it's the idea that if I do a whole bunch of work in the business, but then actually I leave and I decide I'm going to go back to my day job or whatever, I shouldn't still hold on to those shares. I shouldn't still have that part ownership of the business, because then that really stops the business from being able to grow, stops you from being able to bring other people in to push forward your vision and help develop the game. So it's a really important area to get right, and it's one I see people making a lot of mistakes in. If you're lucky enough to get some investment into your studio, whether you have an angel investor come along and say, here's 50 grand, work for another 3 months and make a demo, that's really important to record here, because there's accounting and tax and a whole bunch of different things, and it's doable, but it is worth thinking about. On an ongoing basis, what you generally see in a shareholders agreement is directors who can appoint the directors. So the directors make the decisions, they govern the company. So that's really important to know. If you've got 25% of the company, do you have a right to appoint a director? What about at 10%? What about at 50%? There's no kind of one right answer here, right? Decisions and decision making, you want to be really clear around. If there are certain things you go, okay, there's 5 of us in this company, we've all got different percentages, there are certain things where we all need to agree to do a thing. Or actually, can the board just get on with it and do things and it doesn't really matter? That's the kind of place you want to put it, is in your shareholders agreement. Finally, issuing and selling shares. That's issuing new shares, that's how you grow, is someone gives you some money and they get some new shares in the company, which is great. Selling shares is, you've been in the business for 3 or 4 years, you want to sell some shares down and get a bit of cash out and, buy a house or put a deposit on a house maybe. Can you do that? Is that easy? What are the rules around that? Generally there will be some rules, and it can catch you out if you haven't really thought about this stuff at all. So these are all points you can think about early on and at least get some vague agreement on, or ideally get a written agreement. So the tip here was to sign a written shareholders agreement with a competent lawyer. If that's too hard, at least talk about expectations. At least talk about, well, where are we going? Like, what do we expect this studio to do? What's the end game? What does it look like in 5 years' time, in 10 years' time? Are we going to try and attract investment? If you want to do that, you want to start planning really early so that it is really easy, well, not really easy, easier when you go to do it. So that's probably it for shareholders agreements. Definitely something that comes up time and time again is people who don't have one at all. So there was a case where there was a sale of a business for about $100 million. This was not in the gaming space. And there was one shareholder who had maybe 4% of the company, so tiny. And in the scheme of things, you kind of go, well, they're not going to be that important. They're just going to get some of that money, and great. They agreed to the sale, so cool. $100 million split, 4% of that's pretty great. And then when they came time to actually sign all the documents, they said, you know what, we've actually worked really hard. You should give us another $2 million. And so the majority shareholder with 96% of the company said, no, you can't just demand money from us to do a thing. That's blackmail, right? That's extortion. But in this context, it's not. And they paid the money over, and then they sued them to try and get this money back. And the judgment, well, yeah, morally, not great, not what I would do, but it's not actually blackmail. They were entitled to do it under the shareholders agreement. They hadn't got good advice. And so this guy was able to, get another $2 million by, no judgment, but a little judgment. And it could have been avoided if that company had got, $5,000 worth of legal advice, a couple of years ago. So it does have some really big impacts if you get this stuff not quite right. So we're going to talk about contractors and employees. I don't know whether Mario is either of those. He's probably a contractor, probably a sole trader actually. We're going to start with a little quiz. So we've got 2 photos coming up and we're going to guess which one's the employee and which one's the contractor. So we've got this chap on your left, pretend it's McDonald's. I didn't know whether I had the rights to use McDonald's images, so I got that one off Unsplash. He does the hours he's supposed to do. He wears a uniform. He makes the food in a certain way. He kind of has to do what they tell him to. Do we think he's an employee or a contractor? Employee, cool, we're all on the same page. And that process of elimination, she's working from a cafe, she's doing something with a computer, setting her own time schedule, wearing whatever uniform she wants. Doesn't really matter as long as she gets the work done. Contractor, right? So nice and simple, except this little gap here is actually giant. And we could take a whole bunch of different examples and actually who knows whether they're a contractor or employee. Courier drivers, do we want to have a show of hands for courier drivers are contractors? Yeah, you've stolen the point, but you're right. So generally they've been treated as contractors, and the people who get them to do the work say, yeah, you're a contractor, here's an independent contract agreement, do all these things, yada, yada, yada. Every once in a while, one of them goes, no, sues the company, takes them to employment court, says, actually, I was an employee. And sometimes they've won. And because they've been being treated like contractors, and not treated that well either in most of these cases, when you look at it as, okay, you should have been an employee, suddenly you've got holiday pay entitlements, sick leave entitlements, discrimination, bullying type entitlements, good faith, a whole bunch of things. That means that when you look at them as, you know, as a contractor, probably the company wasn't doing too bad a job. But if that person was an employee, they were doing a terrible job. They were breaching all their legal obligations as an employer. And they get sued for $50, $100, $200,000, which at an early stage is probably the end of the business. These ones, they just suffer a little. So look, it is really important. It's not black and white, and it does change over time. So at the moment there's a screen industry workers bill before Parliament. NZGDA submitted on it a couple of times. A few others have put in some thoughts. I won't go into the background about them changing up the law so that Lord of the Rings could come here. We'll just skate over that. But now they're looking at kind of evening that up, and I don't know quite where that's going to land. But it is really important that you understand that difference between contractor and employee. As a general rule, people often contract someone to start with. Once they know they're good, and once they know they work well, they go, right, we'll now make you an employee and give you all those other benefits and entitlements. So really the tip here is to think before you hire and also get it in writing. Either way, you need a written agreement. If you don't have a written employment agreement, it's a $1,000 fine. It's one of the few areas that I touch on where actually you can quite easily get a fine. But more than that is, if there's ever a dispute and you don't have something in writing, it's going to make life harder, you're going to lose more money, you're going to have more stress, and it's just not going to be great. We acted for a company that came to us and said, hey, we've had these 4 contractors say that they're actually employees. And we looked at the contract and said, okay, and how do you actually manage them? And they told us, and we were, okay, yeah, no, you're a little screwed. That's a technical legal term. So they ended up, I think they had to pay about $100,000 to these 4 contractors who are actually employees. And if they'd come to us 2 or 3 years ago, we would have said, okay, look, you can't actually do it this way, here's how you have to do it. And it would have cost them $3,000, something like that. So for most people, $3,000 or $100,000, it's a pretty easy decision if you know about it in advance. So we're making really good time. Intellectual property. Has everyone played Guitar Hero? Yeah, or Rock Band, or any of the other clones. So you look at this and you just see an arcade. I look at it and I see a whole bunch of different types of intellectual property. So we have Guitar Hero, and you might be able to see a little TM up the top, which means it's a trademark. I would have thought it would be a registered one, which is the little R, but maybe that's different for the States. That's a name that you can trademark. So if I wanted to make a game called Guitar Hero, I would get a very nasty letter from Activision telling me to not do that. Maybe not quite so kindly. The controllers down here, there might be a patent there because it's actually kind of a new invention. There might be a design registered around the shape of the controller. In the game itself, there'll be copyright automatically in all the code, and there'll be a whole bunch of things behind that of all the tools and frameworks they use. There'll be licenses for each of those, which hopefully Activision understand and have put in the appropriate notices, and that can get quite complex. I was going to say there's goodwill and brand reputation, and I made these slides a while ago. So Activision, Blizzard at the moment, maybe don't have the best brand reputation, but that is a type of intellectual property, and as you can see, you can lose that relatively easily. There's also what kind of isn't as obvious is trade secrets and know-how. So if I wanted to make a game like this, there will be a whole lot of kind of tips and tricks around how to make that game work well, and how to keep people engaged, and how to do the progression through levels, all that sort of stuff. That's intellectual property. You can't just go out on your own and make that up. You have to kind of learn it somehow. So even in just one game like this, there's a whole lot of intellectual property, and it's basically their entire business. So Activision will have some desks and company cars and a lease on an office. Let's say that's worth $1 million. This IP alone is probably worth 1,000 million or however much. And when you look at their whole business, the tangible assets, the things that you can touch and see and feel, are just a fraction of that company's value. So it's really important that you do understand the value of your intellectual property. And that goes both ways. I do get lots of startups to say, I've got this really great IP, and you look at it and you go, well, there's not really anything there yet. You've got a good idea, but you can't copyright an idea. You can't protect an idea. You just have to do it better and faster than everyone else. So, intellectual property, it is your key asset. It can be complex. It doesn't have to be. It doesn't have to be scary and intimidating. But when it's the bulk of the value of your business, kind of that, and your people, I should say, actually. Your people are really a really important asset to your business too. When it's the bulk of your value in the business, you really want to make sure you're protecting it properly and taking the right steps. I think of it as a sword and a shield and a power-up. So a sword in the sense of stopping other people from copying you. There's definitely been companies that have, say, gone to certain markets overseas, which shall remain nameless, and immediately they get everything copied. And if they haven't actually done that IP protection, which in that case is going to be quite expensive, then they don't make any sales. They don't get any downloads because there's another one with the same name, which has just copied all their hard work, and it's above them in the App Store, and that can actually happen. So it's useful as a sword to prevent that. It's useful as a shield when you come up with a name or a game and someone comes in and says, no, we've already got that protected. We've already got that name. And we get this on a reasonable amount of times as some big American firm saying we've registered here and change it or else. And if you're an early stage, you might say, we did this once. You said, well, okay, give us $5,000 and we'll rebrand and repaint. This was a physical business, and they said, yeah, sure. Damn, should have asked for 10. So it is useful. If they'd had that protection already, then you could have just thrown that letter in the bin. Don't actually throw a letter from a lawyer in the bin. That was metaphorical. Still give it to your lawyer and check that it's legit. So it's also a power up in terms of, again, the value of your business. And if you are looking for investment, if you are looking for attracting people, you've got more value there. And if you do that right, great. If you get it wrong, not so much. So we had a business that it had been around for a while, and it was going to sell for, I think, $20 million. So it was a great payday for the founder. That worked really, really hard over the last 5-10 years. The investor was looking in, did its due diligence on the business, and found that some of that core IP that really gave them their competitive edge was not owned by the company. It was, I think, owned by one of the developers who had worked on it without any contract, and it was just too big a risk for them. You know, they could have spent all this money and ended up with nothing. So that deal fell through. So, you know, the guy didn't end up in jail or, you know, with a complete failure of a business, but where he could have walked away with $20 million, they did not. So that's not great. So there are some really important consequences, but there's also, thankfully, some really basic things, some fundamental things you can do to make life a bit easier. As a first step is just understanding your assets, your gaps, your commitments, what you have, what you don't have, and what you've agreed to do. Anytime you're signing a contract, which we'll get to shortly, you want to know what's the position on my IP. Hopefully, nothing. I have seen ones where you're doing something almost for free, and they say, oh, and we'll own all the IP. And you go, no, don't sign that. Definitely don't sign that. You'll be signing away your entire business in return for nothing. So it is important to understand what you're actually committing to. And you want to look at things like, if anyone's worked on the game, have they signed something assigning their IP to the company? If they haven't, can you get that done? Or can you kind of look at it and go, actually, no, they didn't make anything of value. But if they have actually contributed to the code, then you really want to try and sort that out. So the tip here is to have an IP strategy. This could be 5 bullet points on the back of a napkin. It could be 20 pages and you paid tens of thousands of dollars to some kind of IP firm to come up with this strategy. It can be really important for timing, especially if you're going overseas and you're having that global view to know, right, we're going to hit this market now, which means that gives us 6 months to do this and build out into this, which is then another 12 months, and it can get really complex. And we've definitely seen people get that wrong and go, oh cool, we filed, this is more like a provisional patent or something like that. And, oh, we filed that, and like, great, now you know you've got to get everything done within 8 months. And they go, oh, we don't have the money for that. Yeah, okay, so it's going to be interesting. So have some form of IP strategy, don't just ignore it. Make sure it covers the basics, and that's around making sure you own the IP you think you own, and especially from a game development perspective, is understanding what all is going into your game and that you actually have the licenses to use things. So all the photos on here are from Unsplash mostly, so the commercially licensed. So I should be able to use them. I really didn't want to, you know, breach someone's IP when talking about IP. I think that's poor form. But I could have easily used a whole lot of more memes and game photos, but I thought, no, I better do it properly. When you're making an entire game, it's a lot more complex as to what goes in there. So we're making really good time. Sorry, we're going through pretty quickly, but hopefully you're all still with me. Contracts. Contracts are fun. I want to start with a question. So what was the last contract you entered into? Anyone want to be first? Employment agreement, or, yeah. Student loan, yeah, that's a good one. Cool. Over that. ESOP pool, cool, great. Anyone else want to throw some out there? Residential tenancy, if you've just moved and you're...
Casual contract?
Yeah, casual contracts. You have a contractor agreement or an employment agreement. I'm just going to have a quick look around. I think because we're just after morning tea, my normal segue won't work. Who bought a coffee this morning on the way to the conference? 1, 2, 3. Okay, yeah, quite a few. I'm going to say if you bought a coffee this morning, then that was the last contract you entered into. And we don't think of buying a coffee as a contract, but that's really all it is. It's, I'll have a flat white, here's $4, $5, here you go. And that's it, right? It's really nice and simple. Except when we actually look into it, and when I put on my lawyer's hat and go, okay, what does it actually look like as a contract? There's a lot there, right? When do you pay? Well, you pay before you get it, right? Unless you're sitting down at a cafe, in which case you can pay at the end, probably. How do you pay? Do they accept credit card or just cash? Is there an extra charge for credit cards? What's the coffee actually like? Okay, it's a flat white, but what does that mean? It's got to be hot, it's got to be fresh, it's got to be in a cup. If you just hold out your hands and they pour the hot coffee on, then that's going to be quite painful. So when we think, okay, it's super simple to buy a coffee, we don't need 20 pages of legal wording. We don't, because we're all on the same page and we all have the same assumptions and expectations. When you get to a commercial contract, who knows? What's the IP position in a publishing agreement? What rights do they have? What do you keep? where can you do certain things? When do they pay? How much do they pay? These are all open for discussion, and there's no real standard position, and even if there was, people won't necessarily follow it. So while it's easy to write a coffee contract, it's a lot harder with everything else you're going to enter into. And that's why we write things down. Partly it's because lawyers like protecting against lawsuits and things like that, but mostly it's about drawing out those assumptions and expectations and making sure that everyone is on the same page. So what does this mean for you? Really, the key point, and this came up yesterday at the investing one, which was a really good point, read the contract. I once read terms and conditions just for fun, and I ended up with $150 credit with my power company, and it was great. And it's the only time that's ever happened. So, always read the terms and conditions. Although I downloaded a game on Monday, and I was like, oh, I have to scroll down to the bottom. Nah, I'm sure it's fine. So, do what I say, not what I do. For business as well, there's that split. When you're a consumer, you have a lot of protections in place, If there was a clause in there that said by agreeing to the Google terms of use, you sign over your firstborn child, that's not going to be enforceable. Don't worry about that. Some people may want to sign over their firstborn, depending on whether they're up crying all night or anything. But when it comes to business stuff, you can get some quite nasty things in there. So we had a client, and they came to us and they said, hey, we got this consultant to do a bit of work. It was about $5,000. And they said, here's the contract. It was a one-pager, nice and simple. When you read it, you go, okay, yep, it covers the basics. It's got do this, do that. Yeah, if you don't pay on time, there's a 1.5% daily interest rate. And okay, cool. Yeah, hold on, 1.5% daily interest. Anyone good at maths know what that is? Over a year, it's 500, 600, 700% compared to your 5% home loan rate, right? So it's an insanely high interest rate. And you didn't really notice it because it's just adding one word in there in a place that it normally wouldn't be. And sure enough, the consultant sent them a bill and they said, look, you didn't do $5,000 worth of work. And the consultant said, yeah, we did. No, you didn't. No, we didn't. Yeah, we did. Went on for a little bit, about a month or so. And then the consultant went, okay, we're activating this clause. We're going to charge some penalty interest. You now owe us $40,000. And they came to us, and obviously they didn't come before they signed the contract, and we looked at it, and our litigation team had a look, and we went, yep, it's been nice knowing you. There's not a lot you can do at that stage. And a funny fact there, and this is when it comes to like red flags, they asked around about this consultant afterwards, and everyone said, oh, don't work with them, they're real shady. They're real dodgy. Don't go near them and like, I wish you had done that first. So, ask around about the people you're going to be working with. It doesn't come up a lot. That's my one example of that, over however many years, but it can happen. The more common one is just not being aligned and not being on the same page. You need to understand what you want out of the deal and what they want out of the deal and make sure that those two things actually match. So when you're reading a contract, understand these 4 points. Who does what, who pays who and when, what's happening with your intellectual property. Again, it's that key asset, it's so important. And how long is it for? How do you get out of it? Those 4 should be covered at least. There's about 20 other things that probably should be covered as well, but we'll stick with the high level stuff for now. So the tip here, A, read the contract, but B, test your assumptions. Sometimes it helps to give the contract to someone else and say, hey, what do you think this covers? Like, what do you think this means? And if they go, I don't understand this at all, then you maybe need to put in a few more words around actually what is it you're going to do, what are we going to do, when do we need to do it. You get all that commercial and practical stuff sorted, and more or less everything else will flow nicely. So those are the 5 areas, but we do have a bonus tip, which is to ask for help. I work with a lot of startups, and often it's a bit scary to go talk to a lawyer. They charge lots of money. They're intimidating, they wear suits. I normally wear a suit, but I decided to be a bit more relaxed today. Don't be afraid to ask for help, and not just from lawyers and accountants and other professionals, but there are a lot of government agencies and NGOs out there that can actually support you. There's a lot of resources online that can help, and it can make this stuff a little bit easier to manage. So my top 2 recommendations, companiesoffice.govt.nz, that's all about making and running a company and that corporate Companies Act type stuff, which is really important. Very easy to understand. You do have to spend a few hours, but you'll get there. IPONZ is the Intellectual Property Office of New Zealand, so that gives a pretty good overview of kind of the registrable types of intellectual property. There are other points there around kind of the contracting side, which, yeah, you can probably find elsewhere as well. But that's a good resource, even just for understanding what a trademark is. Because I haven't really talked about what a trademark is, what a design is, what a patent is. Each of these points we could spend a whole hour on. IP we could probably spend a whole day on, but that would be really boring. I try my best, but yeah, a day of IP is pretty painful. So Startup Dunedin, I talked about them before. I am going to do a little plug for them. I don't do any of the work. There's 3 people who do all the work, and I just sit on the board and kind of help and guide and stuff. So I have no hesitation saying they're awesome to work with. If you go on their website, you can submit a lean canvas, which is a 1-page business plan, and then you'll get 15 to 30 minutes of feedback and advice on that, along with some tips and some connections on what else is out there. They're really good at knowing all the support that's available and hooking you up with mentors and resources and funding and things like that. So really, really good. More focused on Dunedin, but go on anyway. There is also a resources section which we're working on at the moment, and hopefully most of this presentation today will be up there as articles. I've written about 5 articles on this kind of point, and if you forget anything I've said today and you don't want to watch the recording, go on there and have a look. They're also on my LinkedIn and on the Galloway Coquelin website. So if you've forgotten anything, go have a look, and there are some good resources there. There are also other law firms that do kind of explainers and tips and tricks of different quality. But when you're asking for help, a good lawyer is worth their weight in gold, and it may cost you that. Not always. Well, a good lawyer will actually understand, hey, look, you're just starting out. Let's figure out what the most important thing is for you, give you a fixed price on that, and take a bit of a hit, but it's worth it because you're helping grow a whole new generation of game developers and a whole new industry in New Zealand, which is really, really exciting. Ask around about lawyers. Obviously, I'm going to say I'm great, but take that with a grain of salt. Ask for recommendations, but take them with a grain of salt as well. Sometimes people say, oh, they were terrible to work with, and actually there was some other issues going on. But talk to others in the industry. You want someone who understands the industry enough without being a super specialist. It's kind of a trick to get the right kind of person, and having the right attitude, I think, is really important. But again, that could be a whole session on how to engage a lawyer and what to look for, and it would probably be not just me talking, it would be a panel or something to pull me up when I'm talking over. So we're almost at the end. We made it through. To recap, make a company if you haven't already. That's a really good tip. Talk about your expectations with your co-founders and what you all want to get out of it, and think before you hire a contractor or an employee. It is doable, but you do need to get that right. Have an IP strategy that covers at least the basics, if not a bit more. Try and understand whether you actually need to spend $20,000 on a big IP firm's advice, or whether you actually just skate by and you're kind of all right. And it very much depends on the type of game. Different if you're mobile, different if you're on PC. Board games and card games entirely different again. So it really depends on your specific circumstances, and there's no one size fits all. Read your contracts and test those assumptions. Make sure you actually are on the same page. Think about it like a coffee contract, and think about all those things, your obligations, your payments, IP, and termination. And don't be afraid to ask for help. I'd say lawyers are a friendly bunch, but often we are. So often we aren't. Okay, it's a bit of a mix. So don't be afraid to ask for help. I've got a couple of things to say at the end, but we've got about 3 or 4 minutes for questions, so I might start if you've got ones on the app.
Yeah, I actually got a few. What is goodwill legally in terms of IP? What does it entitle you to?
It's something that's made up, but also really real. It's a real hard definition. Goodwill is basically people thinking you're good, people liking you, if that makes sense. So, as I said, Activision don't have as much at the moment. NZGDA probably has a lot because everyone knows NZGDA and thinks they're awesome. They run an amazing conference. I'd hope our firm has some goodwill in the marketplace. We've got, oh yeah, Galloway Coquelin, they're pretty good. I know blah blah, and she's really onto it, So that's kind of goodwill. It's quite a amorphous concept. Cool.
So another question is, many startup studios can run a loss for many years while developing their game. Does this raise red flags with accountants, and how can you deal with it?
Ask an accountant. You can make a loss. I mean, I think Instagram is still making a loss. I don't really understand the business model, but any tech company is going to run a loss for a number of years, but it's often around what the goals are and what it looks like. So you can raise money, lose a whole lot of it, and then raise some more. If that's what you wanted to do, then that's fine, and that's going to work. You do have to be careful around cash flow. I mean, so we didn't talk about why businesses fail. There was a study done, and about 7% of businesses fail because of legal issues, right? So almost nothing. So that makes me feel a lot better about the things I do. The main reasons you might fail is your game isn't that great, and people don't want to play it or buy it or pay money for the optional stuff. Your team is dysfunctional, and you have a big fight, and that just doesn't work, or you run out of money. Like, those are kind of your three main things. So legal stuff's important, but I'm always looking at, well, those other 3 points: your cash flow, your validation of your game, and your team. Those are kind of the three main points.
This is from what I got from Eventy. Are you
Cool.
I want to ask questions right now? Yes.
So with that recommendation to start a company, like, would you say that holds pretty much immediately if I'm working on an indie game with a friend, and like, should we wait until if we're not actually
Yeah,
spending
it's tricky, right? On the one hand, part of me, the startup me says, wait until you've really validated that this is something you want to do, that there is a market for the game, but don't wait till launch. The lawyer in me says do it straight away, but it's not always appropriate. Like I said, it's $150. If the situation between you and your co-founder is pretty simple, then that may not be a big problem. It's how long is a piece of string, unfortunately, and I'm hoping at some point I'll be able to say, here is the exact answer, here's the formula, go work it out. But again, you're probably better off too early than too late. All right, probably got one more. Yep.
Sort of a related question. If you have $0 and the lawyer's fees might be $5,000 to save you 100 or 200 or millions later, is there support for, I guess, startups in terms of paying their legal fees early? So that
Yeah, there's a little bit. So depending on where you live, so Startup Dunedin has a program called the Distiller Incubator, where there's up to 20 grand support from us as lawyers, Deloitte for accounting, and Firebrand for marketing. And so you might get, $1,000 to $3,000 to do a small job, which is great. Other cities will have their own programs like that. You can get some stuff online. You can get some stuff free. If you've done it all before and you just need kind of a document and you know what you're doing, that can be really useful. If you're completely new, then you probably want some wraparound support and some more advice. It's hard though. It is really hard when you have zero money, but you do need a whole lot of advice. The best thing I can do is the more you can validate and show you've got promise, the more people can be pulled along on that journey with you and go, okay, yeah, I'll do this for free. I've done a whole bunch of jobs for people for free, and I'm getting better at knowing when to say yes and when to say no. But when I can look at a business and say, okay, yeah, there's some potential here. Yeah, I've got confidence in the team. There's a market for that game. Okay, yeah, I will give up $1,000 of my time because I want to see them succeed. And you might have to shop around a bit. You might have to call in some favors, or you might just have to come up with some money from somewhere and get that stuff done well, or deal with it later. That's probably all we've got time for, so I am just going to quickly say, if you want to continue the conversation, I'm going to be hanging around. I'll be at the party tonight as well. I'm on Discord. I've never really used it for business, so I don't know whether that'll work. That's just for gaming. I'm on LinkedIn. That's probably the best general platform. I've got my email up there, but it's really long. Our emails are way too long. So any suggestions for that? There is already a GCA legal, so we can't use GCA, unfortunately. But you can also just Google Wade, Pearson, NZ, Gallo, Coquelin. I'll pop up. It's a small country. So thank you all for coming along today. I've had a blast over the last couple of days, and I'm really looking forward to the rest of the conference. I hope you've learned a lot. I hope you feel empowered and reassured that law doesn't have to be scary. And I hope you've had some fun, and I hope you leave as happy as this guy. There you go. Thanks for coming.